All rise. Court of Appeals Division 1 is now in session.
Please be seated. Good morning, counsel.
Good morning.
Let me call this case. This is a case CV2000, well, our case is CV140684, James Gerlach versus Uptown Plaza and Associates. This is the time set for oral argument. Counsel, as you know, these proceedings are recorded. You each have 20 minutes. When I mention that the proceedings are recorded, it's audio and video recorded, so this will be uploaded to the internet at some point, and I want you to be aware of that. Identify yourself when you come up to the podium, if you would. We want to make sure we have the right names here and your client. If you have, as appellant, some time you want to set aside for rebuttal, let us know, and we'll try to keep track of that for you. We've read the briefs. We've discussed the case. We're very familiar with the issues, so keep that in mind. And you can keep track of your time with the clock on the podium in front of you. With that said, is it Mr. Rotz?
Correct.
Did I pronounce that right?
Yes, you did.
All right. Please proceed.
My name is Andrew Rotz. I'm appearing on behalf of the appellant, James Gerlach. We're here today to discuss a case where the trial court granted a motion to dismiss despite proper allegations invoking the discovery rule. Further, the trial court made this determination by incorrectly ruling that the plaintiff did not exercise reasonable diligence as a matter of law, despite allegations of fact to the contrary. A motion to dismiss and a statute of limitation question of law issue are reviewed de novo. When you are reviewing a motion to dismiss, we should take all the facts alleged in the complaint as true, and the plaintiff, appellant in this case, should be granted the benefit of all the reasonable inferences that can be drawn from those alleged facts.
Let me jump right into the Gus Rosenfeld case, because that's a pronouncement by our Supreme Court about what the important focus is on the discovery rule, and this is a quote from the case. In our view, the important inquiry in applying the discovery rule is whether the plaintiff's injury or the conduct causing the injury is difficult for plaintiff to detect. Isn't that the proper framework for us looking at whether or not, as a matter of law, the discovery rule applied here?
Well, the difficulty to detect has been expounded upon by other cases. You're right. I mean, obviously, you're correct that Gus Rosenfeld is the seminal case and really laid all of these things out. And I'd like to draw an analogy to that case as I move forward. But Gus also said a blamelessly uninformed plaintiff that did not sleep on its rights should not have this rule held against it. And the difficulty in discovering the defect is addressed in the fact that the burden of determining and disclosing the square footage, which is the issue in this case, square footage and the rent that's based thereon, was shifted to the landlord, the lessee, or the lessor.
The burden under the contract, at least.
Correct, yes. But, I mean, it's reasonable when you've contracted to shift that burden. And some of the other cases that we've cited today will demonstrate that that logic is that if you contract to shift that burden, it's reasonable to rely upon the other person performing that burden.
But the Gust case also goes on to put a bit of a caveat on what you're saying. It says, but so long as a party exercises reasonable diligence in monitoring the performance of another under the contract. And so the Gust case, there clearly was reasonable diligence. Mr. Gust called and said, hey, have you given anybody else more favorable rent than us? And the leasing agent said, nope, and we never will. And that was false. We don't have anything analogous to that in this case, do we? We don't have, for example, Mr. Gerlach calling up Uptown's leasing agent and saying, hey, you did verify after the build-out, right? If you did, I think that'd be really helpful to you and consistent perhaps with Gust in making it a question of fact. But what do we have here that shows reasonable diligence in monitoring Uptown's performance of that clause?
I agree. That would be helpful if we had it here today.
I'm sure you do agree.
What I think that points out, though, is that in the Gust case, he had inquiry notice. If you read the facts of that case, He spoke to another attorney at Snell and Wilmer who said that, hey, we had just been asked to waive our most favored nations clause, which gave Mr. Gust inquiry notice. He said, oh, wait a second, you have a most favored nations clause also? So he checked in. Inquiry notice in our case didn't happen until much later. And if you look at how the courts have defined this reasonable diligence.
But wait, going back to Gus, the other thing, though, that I think is important that I think distinguishes it from this case is, as the court found, Gus had no ability to know whether or not the leasing agent or the lessor had given more favorable terms to Snell or anyone else. Here, couldn't your client have determined the square footage? I mean, there was nothing difficult about determining the square footage, was there?
Not in and of itself. He did have opportunity and the ability. I think that it more hinges on the inquiry notice. But to go back to your analogy to Gus.
Let me stop you there for a second. I mean, the amount of the lease that he was going to pay is based on the square footage.
Correct.
I mean, you don't think that places some type of inquiry notice on your client? I mean, it's going to calculate how much he has to pay in rent. Why wouldn't you check the square footage to make sure you're paying the right amount in rent?
Well, when the square footage was offered up in the beginning, there was a true-up provision put into the contract. And that provision was meant to and is intended to reassure the person that, hey, after we do our build-out, because that will alter the shape of the premises.
I want to focus you on something. It would be different if the lease was just for a certain amount and it wasn't determined by the amount of square footage, right?
Correct.
That really wouldn't put as much emphasis on getting the square footage right or making an inquiry that the square footage was right. We can agree on that, right?
Well,
I mean, if it's just, here's the space and you're going to pay $1,000 a month.
Right.
But when you're talking about this is how much you're going to pay and it depends on the square footage, you don't think that puts any type of inquiry notice on the tenant to make sure the square footage is accurate?
It could if it weren't for this reassurance, I think, that is provided for in the contract. When you specifically promise someone, and the Gus case says that you should be able to rely on the promise of the other because the most favored nations clause put a burden on the lessor to report if there was a deviation.
Did Mr. Gerlach have any, beyond the contract itself, after the actual build-out, did Mr. Gerlach have any information coming from Uptown regarding the square footage?
No.
Which way does that cut? Is he entitled to rely, or should it have put him on some sort of inquiry that he never heard from him?
Well, I think that in a circumstance like this, silence could be deemed that, especially because it's a verification, not necessarily some sort of affirmative change that would have to happen. I think that it's reasonable, and the case law says what's a reasonable person? Are they put on notice? I think it's reasonable then to say, well, if they're not changing my square footage, then they must have had it right the first time. They've verified it. So I don't and when you look at, for example, in Walk versus Ring, they talk about what puts a reasonable person on notice, and that's the core question. I think that it's reasonable and that Mr. Gerlach acted reasonably in presuming that this person is performed. And Gust, which obviously is such a persuasive case in this, specifically talks about that when the other person has a duty to perform this under the contract, you shouldn't have to monitor so closely. A promise is enough.
But there
a
needs
promise
to be some
perform.
monitoring, according to Gus, because the part I just read. But so long as a party exercises reasonable diligence in monitoring the performance of another under the contract, the discovery rule can apply. So I'm looking for what's the hook here where your client exercised, quote, reasonable diligence in monitoring the performance of another under the contract.
Well, like in Gust, the monitoring that Gust did was strictly when they received inquiry notice. They spoke with this other person who said there may be an issue. He reached out to the leasing agent. In our case, when my client received inquiry notice. He was told, hey, I don't think that the square footage is correct. He reached out to the lessor, and that's when he made actual discovery. And if we look at the facts as pled, and we consider those true, what we've laid out is actual notice and inquiry notice. And at this stage of the case, I think at the very least we have a material dispute of fact as to whether or not this was a reasonable exercise of his diligence. This is when he got inquiry. This is when he had actual.
You don't think he had inquiry notice when he had to pay that first month's rent? Because it's calculated based on square footage?
Not necessarily. I don't think that every commercial tenant goes into leasing a space and hires a surveyor to come out and determine the square footage. It's reasonable to rely on the person who has provided you the space, provided...
I understand your argument. What if he thought he was getting 2,000 square feet and he got 1,000?
Well, that would be a much larger deviation, and then a question of fact would maybe arise. Could he see it? Was it open and obvious? And I don't think that this deviation is open and obvious, particularly because we're talking about the inclusion of a storage area in the back of the store, which he did not believe was a portion of the rented space. It's 200 square feet, so it's small enough that it wouldn't be considered open and obvious. At least there could be a dispute to that question.
What kind of business was it that your
It was
client?
optical eyeglass services, sold glasses and
Optician.
prescriptions. Yeah.
He didn't care about a storage space in the back of his leased area?
Well, it was supposed to be walled off. Well, it was walled off when he got it. The storage space was actually to be used by the landlord. It connected to their electrical facilities for the entire strip mall. And under the lease, Section 4.8, an area like that where the landlord needs continued access to it is more considered a common area, and it's not leasable space. So he was under a contractual and a reasonable assumption that, hey, this isn't part of the leasable space that I'm getting. Uptown knew that he didn't think that. Their representative told him that it wasn't part of it, gave him a site map that showed it as being walled off, and charged him for it anyway. So I think that it's not a condition that's open and obvious, but at the same time, it's something that was concealed and was charged against my client inequitably.
Where does the rest of the discrepancy come from? Any place in particular?
No, not that I'm aware of. Basically, there was a survey done. There's a discrepancy as to the storage area, whether or not it's included, but there was a discrepancy beyond that of less than 100 square feet, but a significant amount when you consider monthly rental charges.
In the allegations in the complaint, are there specific allegations regarding the storage area?
Yes, there are. That it was to not be included, that it was represented that it wouldn't be included, that he received a site map that didn't include it,
Then he found, and do those representations include that then ultimately Mr. Gerlach found out that it was included contrary to the representations?
Yes, he did. He discovered that after he received inquiry notice from the person who negotiated a new lease in that same space. He made a demand upon Uptown. Uptown hired a surveyor. That survey came back, and it was clear from that survey that they had included this storage area, whereas he did not believe or have noticed that it was being included prior to that.
So this case is different than saying we're gonna rent you space that we believe is 1,825 square feet, and then after the build out it turns out to be 1,554 or whatever.
Right. It has a different component to it.
This is not that case. This is a case involving a broken promise regarding a storage area.
Absolutely.
What about the lease recital that the, quote, approximate, close quote, square footage is 1,825 gross square feet?
Well, that's offered up in the beginning. Obviously it gives an approximation, but I think that the critical part is that it will be verified. So we're giving you this space, we're giving you the estimated square footage, and we're taking upon ourselves, speaking of Uptown, to verify this after the build out is done. So, I mean, they've taken it upon themselves. Mr. Gerlach didn't have a broker or an attorney. Uptown prepared this contract. They took that burden upon themselves.
I guess what I'm puzzling over in part, and you may have figured this out from an earlier question, is whether the fact that Mr. Gerlach did not hear from Uptown after the build-out and as the lease began, other than in the form of the monthly bills, I guess, does that put him on inquiry notice?
Well, he didn't hear about square footage.
Right.
He heard from Uptown that the place was ready to go, it had passed inspection, and that he could take it over. I mean, this is something that by omission, one could assume was investigated and determined to be correct. If you're saying that, hey, we had our city inspectors, the place has been permitted, it's ready for you to occupy it, and you don't mention that upon our review, our contractual obligated review, we determined it was smaller and we're going to charge you less. I think that by omitting that, they are affirming that they've done their contractual duties. You can rely on a promise to do things. At least you should be able to.
Counsel, I'm not sure I apologize. I may not have been paying as close attention as I should have. But when Judge Downey asked you about the test in Gus, this language, conduct causing the injury is difficult for plaintiff to detect. And what's the meat that you put on the bones to that test?
The meat is basically that it was difficult because they affirmatively, first of all, they lied about, well, lie is a strong word. They misrepresented what the area was going to be. They specifically gave him a map that says this is what your area will be.
Not asking you the facts. I'm asking you in terms of the legal standard. What is that? Do you have any cases that you think flesh that out differently or in a better way? And what does that language mean to you?
That it's difficult to detect. The cases that I believe kind of flesh that out are the ones that deal with inquiry notice, because difficult to detect and reasonable and detectable with reasonable diligence have been used in connection with each other throughout all of these cases. And I think when you see the evaluation on, Logerquist, on Walk versus Ring, even on the cases cited by Uptown, Tovrea, and even more recent cases, the Aprahita versus Porter case, it shows that if they're open and obvious, if you have inquiry notice, then the tolling begins immediately, or the statute of limitations begins immediately. But if it's difficult to detect, if you don't have notice to investigate, if you don't know and you don't have notice to investigate, I think those are the important factors. Look at Walk versus Ring. She knew that her jaw was in severe pain from the day that the surgery was over, but she didn't connect it with negligence or improper conduct by the defendant.
But isn't it distinguishable, a tort case, from the language in Gus? Because Gus does say you have an affirmative duty to monitor performance of a contract. We don't have an analogous holding in terms of, say, a medical negligence claim. Well,
What is reasonable monitoring should be considered a question of fact. Because in Gust, what did Gust do to monitor besides make the phone call after receiving inquiry notice?
Is there evidence in this case that your client did anything to monitor the square footage that he received?
No, he relied on the performance and the promise of performance.
It's different than an affirmative duty. I mean, doesn't he have some obligation to do something? And can you point me to anything in the record that said he made any effort to check on that square footage, either when he came in and looked at the place or when he paid the rent based on 1825?
Well, obviously, looking at the place did not alert him to it. He looked at the place. He was there every day. So it wasn't open and obvious to him. If you're talking about a minimum affirmative effort, he did visually apprise the place, and it seemed to him to be an appropriate measurement of square footage. So in that case, yes. But I think that if we're talking about affirmative duties, when you contract to shift that duty to someone else, then you have met your duty. If your duty is to do X and you sign a contract that says Uptown's going to do X for me, then you have met your duty. If it pleases the court, and I'd want to answer every question you have, but I got about a minute and a half left, and I'd like to save just a moment for rebuttal if possible.
Of course. Thank you, counsel.
Thank you, Your Honor.
All
Thank
right,
you all.
Ms. Gales?
Yes, Your Honor.
All right, your argument?
Good morning, Your Honors. May it please the court. My name is Netta Gales, and joined with me at counsel's table is my colleague Peter Sorensen. We represent the appellee in this action, Uptown Plaza Associates. My intent this morning is to focus my allotted time on the reasons why this court should affirm the dismissal of the complaint on statute of limitations grounds. And unless the court has specific questions, I do not intend to cover the other issues raised on appeal, which are fully briefed in our papers, including the dismissal of the unjust enrichment claim on separate grounds, denial of the motion for reconsideration, and award of attorney's fees. And we'll rest on our answering brief in support of those rulings unless you have further questions.
It seems to me, going directly to the statute of limitations issue, it seems to me there might be two different kinds of cases. One, and this is similar to what I was asking Mr. Rotz, one is where the landlord says, here's their space, we think it's going to be 1825, we'll check it after it's built out, and then says nothing, and it's 250, 271 feet less than that, something like that. But it's a different case, perhaps, if the landlord says, there's this storage area that we're not going to charge you for, and we're going to use, and maybe you can use it too, but we're not going to charge you for it, and then they do charge you for it. Which case is this, or does it not matter?
Your Honor, I would say that based on the allegations of the complaint, this case is the former. It is a case where the allegation is that there was a misrepresentation of the square footage amount in the lease. I will also say that the distinction doesn't matter per se for the analysis, because here the only representation that's alleged in the complaint after the lease was executed is that the storage area was not leasable space. There was no representation that included the storage area in the context of what that meant for purposes of square footage and what the charge would be based on that square footage.
Well, if it was not leasable, wouldn't that suggest that it wasn't going to be charged for?
Your Honor, not necessarily. There is a provision in the contract that provides for calculating the gross leasable area of the space, and while we have not necessarily gone into that analysis because we are not at this stage in a position where we're needing to analyze the merits of the case, it's not necessarily the case that just because the storage area was leasable space that it wouldn't necessarily be included in the calculation. And so another reason why it's not material is if we put things into perspective under the framework of GUST, there needs to be an allegation in order for tolling to apply, which does not apply here, that it was difficult to detect the misrepresentation, purported misrepresentation of square footage, or that it was otherwise concealed from Mr. Gerlach, or that he was prevented from discovering it.
And so had Mr. Gerlach, like Mr. Gust, called up the leasing agent and said, hey, you guys performed and recalculated square footage after the build-out, and was told yes, we'd have a very different case, wouldn't we?
Yes, Your Honor, we would. And as opposing counsel conceded, and as Mr. Gerlach concedes in his reply brief, he had every opportunity to investigate the square footage and verify the square footage during the 13-year period of the lease. He simply chose not to do so. And the only reason advanced by counsel is that he wasn't put on inquiry notice and had no reason to investigate or verify the square footage, simply because the contract provided that Uptown would, if necessary, adjust the square footage of the premises upon completion of the build-out. That as a matter of law, is insufficient to trigger the application of the discovery rule. The discovery rule not only requires that a party exercise reasonable diligence, but also requires that the breach, the alleged breach, was difficult to detect, or that it was concealed from him, or that he was prevented from discovering it. And we don't have either of those components here. There's no allegation of reasonable diligence, and there's no allegation that it was difficult to detect. Now,
What about Walk versus Ring, which Mr. Rotz relies on? And it is a more recent pronouncement by the Supreme Court about the discovery rule. Does that alter the analysis set forth in Gust for a contract case, in your view?
no, Your Honor, it does not. Walk v. Ring is distinguishable here. That case concerned a patient suing a dentist for malpractice. And the dentist in that case was alleged to have actively concealed from the patient that the crowns that were inserted into his mouth were too long and had too steep of an angle. And the dentist also repeatedly, when asked, assured the patient that he had done nothing wrong. The court reasoned that on those facts, no one could say that the plaintiff slept on her rights or had delayed the filing of her complaint. That is not the case here. Here, there is no allegation that anything was concealed from Mr. Gerlach. In fact, he knew what the square footage was. He agreed to pay rent based on a rental amount that was calculated on a square footage amount that was represented to him. And he proceeded to lease the space for 13 years when he admittedly had every opportunity to verify. And there's also no allegation that there were any assurances that were repeated, nor could they have been, because there's no allegation that Mr. Gerlach exercised any reasonable diligence to verify the square footage and inquire as to that.
What about the argument on behalf of Mr. Gerlach that he did not do anything because the contract places the responsibility on the landlord to check this after the build-out and to adjust accordingly, and he never heard from him?
Yes, Your Honor. That argument is unavailing because the law is clear, as articulated in Gust, in Doe versus Roe, and in ELM Retirement Center, Arizona controlling precedent, that it's insufficient to trigger the application of the discovery rule where a party is merely hiding behind its ignorance when reasonable investigation would have alerted it to the claim. That is a duty that is incumbent upon every plaintiff in every action.
There's no right to rely?
Your Honor,
Our law is that a person cannot believe in the good faith and fair dealing of the other side?
Your Honor, the law, while a party can certainly has a right to rely, that does not remove them of the obligation to exercise reasonable diligence in confirming and verifying that reliance. In the cases where the statute of limitations has been told by way of the discovery rule, it is as a result of there being some sort of active concealment or assurances that once reasonable diligence has been exercised, which has not been exercised here, the party is entitled to rely on that presumption. Here, nothing in the contract or anything that occurred after the contract was executed gave Mr. Gerlach the right to rely on the representation and forego his duty to exercise reasonable diligence.
If the contract had required that the landlord check the square footage after the build-out, as this one did, and to notify the tenant of the results of that, would we have a different case? And assume the landlord just said nothing?
Your Honor, I don't know that we would have a different case necessarily, because here Uptown was required to adjust the build-out if necessary. So when Gerlach,
Just the
I apologize, yes.
monthly lease, right?
Yes, Your Honor, adjust the monthly rental figures. So when Mr. Gerlach heard nothing from Uptown, presumably he would have reasonable notice and be put on inquiry to investigate. But we do not even need to get that far here, Your Honor, because there's a distinction between exercising reasonable diligence and inquiry notice. Inquiry notice is an analysis that we only need to apply once we've determined that the discovery rule under the framework of GUST actually applies. Reasonable diligence is a duty that's incumbent upon every plaintiff in every action. Inquiry notice and the analysis of whether it would have been incumbent upon him to be prompted to investigate, we only need to go down that road if we determine that the discovery rule applies. And based on the allegations of the complaint, it does not. Your Honors, unless you have further questions, I have just one final point I'd like to make.
Okay.
Thank you. We have the statute of limitations for a reason, and they are to discourage plaintiffs from sleeping on their rights and to protect the defendants and the courts from stale claims. The problems associated with stale claims include failing memories and unavailable witnesses and documents. And those are not simply theoretical problems in this case. Based on the allegations in the complaint, Mr. Gerlach has slept on his rights, and as a result, Uptown, the trial court, this court, have been burdened with claims that Gerlach could have and should have brought over 17 years ago. The law dictates the dismissal of such claims on a motion to dismiss. And for these reasons, and the reasons stated in our answering brief, we respectfully request that the court affirm the judgment in all respects, including on statute of limitations grounds.
I realize you've just sort of concluded, but
Sure.
before you go, I would like to have you comment briefly on the independent ground for why unjust enrichment does not, in your view, apply.
Certainly, Your Honor. The unjust enrichment claim was properly dismissed because it is an equitable claim where a party can only assert it in the absence of a legal remedy.
If there's a contract, you never get it?
Not necessarily, Your Honor. If there is an allegation that the contract is unenforceable or invalid, then in those cases, unjust enrichment could potentially be pled as an alternative claim. But in cases such as this, where the party has alleged that there is an enforceable contract and is seeking remedies based on that contract, neither party has asserted that the contract is invalid or that it does not provide the parties to the relief that's contemplated in the contract. In that case, an unjust enrichment claim is improper. And as we stated in our papers and cited cases to that effect, that's the reason why we believe that the trial court properly dismissed that unjust enrichment.
A party who might be the victim of a breach of contract can recover for those contract damages in accordance with the contract, but could not recover additional damages for unjust enrichment, no matter how unjust and how much enrichment had occurred. Yes,
Your Honor. Assuming that the allegation is that the contract is enforceable, which that is the allegation here. And the logic of that is the parties, when they enter into a contract, they are in a position to determine what the appropriate damages would be in the event of a breach. So to extend beyond that would be not to enforce the intent of the parties, which of course is the goal of contract law and contract principles.
Like the economic loss rule, which Judge Gemmell is very familiar with.
No, I don't know anything about it.
Yes, Your Honor, it's the same purpose behind the economic loss doctrine as well.
Thank you.
Thank you very much.
Thank you. Mr. Rotz?
If I may, really quickly, to the point of the unjust enrichment, in the Trustmark case, as Judge Gemmell is probably familiar, there was a parallel drawn between the plaintiffs in Trustmark, the Johnson case, and the Brooks case. In all of those cases, the plaintiffs were seeking to avoid limitations on their contract claims by seeking unjust enrichment. It wasn't a true alternative pleading. It was more of a opportunity to avoid limitations of their original claims. This case is more like Edelman, where both are pled. One is in the alternative. And in Edelman, she pled her contract, and it was pled in the alternative that if the contract is deemed unenforceable, then unjust enrichment would apply. In this context, if you look at rent being paid over the amount that's actually due, if this contract were to be determined the contract claims were unenforceable because of the statute of limitations, one could theoretically look to the last 3 years of unjust enrichment that Uptown received. So that's why I believe it stands on its own. It can be pled in the alternative. I want to talk about a few questions and link this to Judge Gemmell's question about which type of case is this. Did Uptown perform? Did they verify? And if so, did they withhold that information? Did they not disclose it? That's a question of fact.
I just want to keep you mindful of the time that we have. I don't know.
I think I'm out, but I'll leave us on one last note. In Gust, Judge Downey, the injury was difficult to detect partly because the plaintiff was relying on defendant to report to it. And I think that you can draw an analogy here.
Well, but there was no way unless they went tenant to tenant in the whole Valley Bank building and said, how much rent are you paying? And then, so the information was not accessible, the court found, to Gus. It was in the leasing agent's knowledge, not within Gus' ability to know. So, anyway, sorry.
I'd love to talk about it all day.
All right.
Thank you.
Thank you, Your Honor.
Thank you, counsel. We appreciate your arguments. We'll have a written decision for you here in due course. Court's in recess.